If she does testify, mark my words, we are going to be seeing sweaters and tissue boxes. How possibly could this 75-year-old grandmother have been the mastermind behind this entire assassination plot? What may be the final chapter of a case over 10 years in the making is set to begin against a Florida grandmother accused of being the mastermind behind a murder. Plus, an Oklahoma pediatrician and mother faces reduced charges for the death of her child. And a former military prosecutor is convicted for the murder and dismemberment of his wife, despite his personal pleas to the jury. All this and more, this week on Courtroom Confidential. We are honored that you have decided to join us this week. There's a lot for us to discuss. We are recording this episode on Friday, August 15th, 2025, and this is your Courtroom Confidential Weekly Roundup. Let's jump in. Donna Adelson was in court last Friday for her final pretrial hearing as the prosecution and defense grappled over last-minute motions and trial logistics. The 75-year-old grandmother is accused of orchestrating the murder-for-hire plot, which led to the death of her former son-in-law, Florida State professor Dan Markel, in 2014. Dan Markel and Wendi Adelson, Donna's daughter, were embroiled in a contentious custody battle over their two sons when Markel was shot in his driveway. 4 people have since been convicted for his murder, including Donna's son, Charlie, who was found guilty in November of 2023 and given a life sentence. During Friday's hearing, defense motions covered issues ranging from whether Wendy's divorce pleadings with Markel can be discussed during trial to how much the jury can be told about Donna's attempt to board a flight to Vietnam. At one point, defense attorney Joshua Zellman asked Judge Stephen Everett to allow testimony about Luis Rivera, one of the 2 hitmen hired to kill Markel, and the fact that he held a leadership role in the notorious Latin Kings gang. He argued that information speaks to Donna Adelson's state of mind when her phone conversations were secretly being recorded. State Attorney Georgia Kappelman, who opposed the request, said she has always argued that Rivera was recruited to carry out the murder because he was a gang member, but that his affiliation with the notorious Latin Kings was more prejudicial than probative. During this exchange, Zellman mentioned that his client would testify in her own defense about her fear of Rivera because of his membership with the Latin Kings. Judge Everett responded saying, "I cannot make her testify. If she committed to do so as part of her defense, that's her choice. But ultimately, someone with competent knowledge has to testify to this fact." On Wednesday, Wendi Adelson, who has not been charged, filed a motion to block her mother's defense team from questioning her beyond what the state allows. Wendi previously testified under a grant of immunity against her brother Charlie during his trial. Jury selection is set to begin Tuesday, August 19th, with nearly 300 prospective jurors summoned. 12 jurors and 3 alternates will ultimately be chosen. The state estimates it will need 5 to 7 days to present its case, while the defense expects to take 4 to 6 days. We will be live streaming this trial on our sister channel, Courtroom Confidential Live Trials, so be sure to subscribe with your notifications turned on so that you don't miss any of the action. What's happening here? Let's talk about first the idea of Donna Adelson actually testifying. Now, why might it be important for her to testify? Well, first of all, her state of mind, what she knew, when she knew it, is going to be what this entire case is about. How much about the planning and plotting of this assassination did she know? And when did she know it? Did she know it ahead of time? Was she part of that planning? Was she aware that the planning was taking place? Or had she only become aware of it after the fact? She also needs to testify to explain some things to the jurors. She needs to explain what exactly she was doing with a one-way ticket to Vietnam when she was arrested at the airport. She needs to explain to the jury exactly what she did and why she did it after the quote-unquote bump. Why did she call her son first and not go to police? Those are important things. Again, they all go back to her state of mind. But is there something else behind this? Does this also have the strategy or design of putting a 75-year-old woman on the stand to elicit sympathy from the jury? If she does testify, and by the way, she's not obligated. Her attorney saying in court that she intends to testify does not obligate her to testify. They could make a game time decision and she could never take the stand. But if she does, mark my words, we are going to be seeing sweaters and tissue boxes, because this is all going to be about the optics to the jury. How possibly could this 75-year-old grandmother have been the mastermind behind this entire assassination plot? That is going to be the purpose of her testimony. But my question is it worth it? Did she not learn anything from watching her son, Charlie, testify? He testified. He seemed to have all the answers, and he went down in flames. He was convicted quickly. The question, though, I always ask in these situations where we talk about a defendant testifying and we talk about whether or not that's a good strategic move or not, is this really a strategic move, or is it perhaps the client insisting upon it? Is it perhaps the defendant saying, I intend to testify regardless of what you tell me, Mr. or Miss Defense Attorney? That is the one thing that a defendant maintains strategic decision-making over. Most defense attorneys can call the shots, how to cross-examine someone, what witnesses to put on the stand and which not, which experts to call. But when it comes to whether or not the defendant will testify, that is entirely within the purview and prerogative of the defendant. And that might just be what we're dealing with here. It could be that there is no clever like a fox behind any of this. It could just be that Donna Adelson insists on testifying. One last thing I want to chat about is Wendi Adelson opposing the subpoena from Donna Adelson's team. What can be made of that, and what shouldn't we jump to the conclusions of? Well, what she's essentially saying here is, listen, the only reason I testified was because I was given immunity in the case against Charlie Adelson, my brother. I was given what's called derivative use immunity. Immunity, we think of sometimes as being a benefit to that person who's receiving the immunity. Not always true. Many times this is a tool by the prosecution to force that person to testify. In other words, Wendi Adelson has a very ripe Fifth Amendment issue at play here. She can say, I know you're investigating me. I know you think I was involved. Therefore, I'm not going to testify. I'm going to plead the Fifth. I have an absolute right to do that, and you cannot compel me to testify. And the government says, aha, we can if we grant you immunity. If we grant you immunity, that removes your Fifth Amendment concerns, your Fifth Amendment rights, and therefore we can compel you to testify. And that's exactly what they did in the case against Charlie Adelson, and that's exactly what they intend to do in this case. The prosecution has subpoenaed her. Now, Wendy's team is saying, okay, fine, I'll testify. I'll be forced to testify, and I'll use that use immunity. But the defense doesn't have that same immunity to grant to me. And so therefore, I don't want the defense asking questions and getting into areas that have not been breached by the prosecution as part of my immunity deal. The defense, Donna Adelson's defense, has also put Wendi on their witness list. And Wendy's concern is that she might be called as a witness for the defense and be asked questions on direct, not limited by what the prosecution has asked her, and therefore not falling under that immunity privilege and protection. Now, is this just smart lawyering? I think absolutely on Wendy's part. But does it also indicate that maybe there is something she is perhaps worried about Donna's defense team asking her? What do you guys think? What do you think is really at play here? What do you anticipate in this trial? Please tell us your surprise predictions. Let us know in the comments. Florida prosecutors have reduced the charge against Oklahoma pediatrician Neha Gupta from first-degree murder to aggravated manslaughter of a child in connection with the death of her 4-year-old daughter, Aria Talathi. The lesser charge means Gupta is no longer eligible for the death penalty, but still faces up to 30 years in prison if convicted. Gupta was arrested July 1st at her Oklahoma City home after investigators allege she staged her daughter's death at a Miami area Airbnb to look like an accidental drowning on June 27th. The medical examiner reported finding no water in the child's lungs or stomach, signs of smothering inside the mouth and bruising on the cheeks, concluding she died before entering the pool. Aria's father, who was in a custody dispute with Gupta, told police he didn't know she had left Oklahoma with their daughter. Oklahoma court records show Gupta had been ordered to undergo a psychological evaluation in May. Gupta's attorney has called the case a rush to judgment, maintaining the death was accidental and criticizing investigators for making an arrest before receiving all evidence, including toxicology results. She will be back in court on Tuesday, August 19th for a motion hearing, and trial has been tentatively set for November. What's happening here? Every time we have a murder, what do we hear about? Means, opportunity, and motive. Here, the means. Do we have the means? Sure, we have the pool. The pool is the murder weapon, if this is in fact a murder. Opportunity. Well, she was away. They were at a rented home. There was no one around. If she wanted to commit this murder, she sure could have, because she had the opportunity. What about motive? Well, the prosecution has already revealed some of that, being this contentious custody battle. We do know that murders unfortunately take place for reasons like this. What about evidence supporting all of this? Well, the medical examiner's report says that there was no water in her lungs. There was evidence, in fact, of strangulation taking place before she entered the water. But what about evidence of premeditation? Well, she left. They went to this home, this rented home outside of the state, away from the father who was not aware that they were traveling. Now, we don't know everything in this case. But from everything I've just described, I imagine you're thinking to yourself, this sounds like first-degree murder. This sounds like premeditation. This sounds like malice aforethought. Why isn't this being charged as murder? I'm actually going to say something that may surprise you. I think the prosecutors are doing the right thing here. Prosecutors are gatekeepers. That is one of the jobs that they have unique in this entire process. Defense attorneys are just zealous advocates. They only move in one direction and they only have one speed. Pedal to the metal, full steam ahead. There's no second guessing the defense of your client within the bounds of the law. But the prosecution doesn't operate that way. They wear two hats. They have to decide, is this the right thing to do? Their job isn't so much, what is the most I can get? What is the highest crime I could possibly conceivably prove here? Their job is, what can I prove beyond a reasonable doubt? And even more than that, their job is, what is the pursuit of justice? 30 years is a very long time. Now, don't get me wrong. I am not trying to say that they should settle here and that they should go for a lesser crime. If they feel like they can prove first-degree murder, then absolutely they should pursue that. But don't we appreciate some discretion on the part of the prosecution? Many times we don't see that. Many times we see prosecutors charging the heaviest crime they possibly can. And what usually ends up happening? Cases start to fall apart. Credibility is lost. The jurors are confused. The jurors see the prosecution overreaching. Time will tell exactly what the evidence is in this case, but I choose at this point to give the prosecution the benefit of the doubt. They're not doing the possible in this case, but they are, I hope, doing the right thing. But what do you guys think? Do you think they got it wrong? Do you think this case is purely first-degree murder? You think they're being weak? Please let us know in the comments. Earlier this week, former U.S. Navy JAG officer Nicholas Kassotis was sentenced to life in prison after he was convicted by a Georgia jury of murdering and dismembering his wife, Wendi Kassotis, in November of 2022. Immediately following the jury's verdict, Kassotis was sentenced to life in prison without the possibility of parole plus 25 years. Hunters found Wendi's dismembered remains in December 2022. Authorities said her remains were found in multiple locations within a 3-mile radius. Kassotis, also known as Nicholas Killian James Stark, was arrested in Lancaster, Pennsylvania on May 12th of 2023. His arrest came one day after Mindy's remains were positively identified through genetic genealogy. Prosecutors claimed the couple was on the run to avoid paying a $1.5 million divorce judgment to the defendant's first wife and that Kassotis was having an affair with a woman he later married. The defense argued the couple was actually running from an individual referred to as Jim McIntyre and said the state's case was circumstantial. Wednesday, Nicholas was the star witness for the defense, and his testimony was the last the jury would hear before deliberation. According to Kassotis, Jim McIntyre was an FBI agent who had been investigating him and a series of violence towards the couple as a result of Kassotis' job. However, on the stand, Kassotis says he felt betrayed for trusting McIntyre to protect him and Mindy. They viewed Mindy as an impediment and that they would kill Mindy if they had been given the chance, Kassotis told the jury. Ultimately, the jury was not swayed by this bizarre and meandering story. After about 90 minutes of deliberations, Kassotis was found guilty on a dozen charges, including malice murder, felony murder, aggravated assault, and tampering with evidence. What's happening here? We can talk all day long about the burden of proof. All day long, we can be reminded that the burden always rests with the prosecution, that it should never shift over to the defense, that the defense doesn't have to present a case, the defense doesn't have to ask questions, the defense can sit on their hands through the entire trial and never say a word because the burden always rests on the prosecution. But I'll tell you this, the second the defendant takes the stand, all that changes. Not legally, not according to the rules, but practically. I'll go a step further. Aside from a few rare exceptions, most times when a defendant takes the stand, all they can do is make their case worse. What do I mean by that? Testifying is not easy by any stretch. Even for a defendant that is well prepared, knows what's coming, has all of the answers, think about the pressure that they are under. Think about the nerves that they must have. Think about facing skilled attorneys who have been cross-examining people all their career. And that's if you're telling the truth. Now imagine trying to perform that high wire act and you're trying to keep your lies straight at the same time. I'll go one more step further. You might as well throw out everything that has taken place in the trial before the defendant takes the stand. Does that sound a little extreme? Maybe it is. But I don't care what reasonable doubt has been sown before that defendant takes the stand. I don't care what great questions were asked, what moments the defense had, how poorly the prosecution presented their case, what points were scored by the defense. By the time the defendant takes the stand, the scoreboard says 0-0, and it's all up to the defendant and how they perform. One mistake, they misremember something. One detail they testified to now was testified to differently earlier, or a statement that they gave to the police earlier. A hesitation, an equivocation, any of that can be interpreted and might be interpreted by the jurors as a person that is lying, not being truthful, hiding some of the truth. And if jurors feel that that person is lying to them, I think it is true. I think whatever points may have been scored before don't matter anymore. Jurors will hang their hat on that alone. As a prosecutor, I loved when the defendant would take the stand. My first question out of the gate was always, you have anything else to add? This is your opportunity. Tell us everything you'd like to tell us right here and now. Because for every word that came out of their mouth, I knew there was another problem. I knew there was something else they were going to slip on. Something else that was going to cause the jurors to say, this person isn't being honest with me. And if they're not honest with me while they're testifying on the stand, I don't know if I can believe anything about their case. Now imagine all of this, as difficult as it is, and your story is that a mystery man, possibly the FBI, who I cannot produce in court, who was pulling all of the strings, who maybe committed this murder, or maybe someone else did. That's your story that you tell the jurors. I'm not saying that Nicholas Kassotis had a case to begin with before all of this, but I am saying that this sure did not help. But what do you guys think? Do you think he sank his case here, or do you think it was already sunk to begin with? Let us know in the comments. Before we dive into the other cases making headlines this week, I'm going to stop for a moment and ask that you do me one very small favor, and that is, if you haven't already, please take a moment to subscribe to this channel now. We want to continue to provide you with the highest quality content that we possibly can, and the best way that we can do that is through your support. Also making headlines, lawyer for a Massachusetts man charged with murdering and dismembering his wife have filed a second motion to dismiss his case, arguing that prosecutors' inability or unwillingness to review materials from a federal investigation that could help his defense was a violation of his rights. Brian Walshe is accused of killing his wife, Anna, in their Kassotis home, dismembering her body in the basement, and disposing of her remains in dumpsters. The dispute stems from evidence gathered during the federal probe into the Karen Reed case. Reed was acquitted this year in the death of her Boston police officer boyfriend, John O'Keefe. Prosecutors say they're barred from searching those files for information about other defendants, but the law requires them to share anything that could help the accused. A federal order also required that materials be returned or destroyed 30 days after Reed's June 18th acquittal. Their 30-day extension expires this Monday, August 18th. The Walshe motion claims that failure to dismiss the indictments or to order the district attorney's office to review the materials would rob him of his rights to a fair trial, due process, and to have effective assistance of counsel. Norfolk Superior Court Judge Peter Krupp has so far avoided issuing an order that might conflict with the federal court, but warned prosecutors they could face sanctions if they don't meet their obligations. The Norfolk DA's office has asked federal judge Denise Casper to amend her order so that state prosecutors can review the material and keep it for 6 months. Federal prosecutors have so far opposed the move. Nicholas Rossi, a Rhode Island man accused of faking his death to avoid rape charges, was convicted Wednesday in Utah of sexually assaulting a former girlfriend. An 8-person Salt Lake County jury found Rossi guilty of a 2008 rape after a 3-day trial where his accuser and her parents testified. Rossi did not take the stand. First-degree felony rape in Utah carries 5 years to life in prison. Authorities linked Rossi, whose legal name is Nicholas Alaverdian, to the 2008 case through DNA from a rape kit tested in 2018. He was one of thousands of rape suspects identified when Utah made a push to clear its rape kit backlog. Months after being charged in Utah County, an online obituary claimed that Rossi died in February of 2020 of late-stage non-Hodgkin lymphoma. But police in Rhode Island, his former lawyer, and a former foster family doubted the story. He was arrested in Scotland while receiving treatment for COVID-19 in 2021 after hospital staff recognized his tattoos from an Interpol notice. Extradited in January 2024, Rossi claimed he was an Irish orphan named Arthur Knight who was being framed. Investigators say he used at least a dozen aliases over the years to avoid capture. He appeared in court in a wheelchair, wearing a suit and using an oxygen tank. Sentencing is set for October 20th, and he faces another rape trial in Utah County this September. 3 people charged with helping a Tennessee man accused of fatally shooting 4 people are suspected of providing him with shelter, phones, and rides as he evaded authorities after the killings, a prosecutor said Thursday. Austin Drummond made a brief court appearance before a judge by video feed on Thursday. Drummond had pled not guilty to 4 counts of first-degree murder in the shooting deaths of James Wilson, age 21, and Adriana Williams, age 20. Williams' brother, Braden Williams, age 15, and their mother, Courtney Rose, age 38. James and Adriana are the parents of an infant found abandoned at a random individual's front yard on July 29th. A manhunt for Drummond ensued and later ended August 5th in Jackson, about 70 miles southeast of the crime scene in Tiptonville. Lake County District Attorney Danny Goodman had said prosecutors plan to seek the death penalty if Drummond is convicted of first-degree murder at trial. Appearing in court by video feed were Tanaka Brown and Deara Sanders, who have been charged with being accessories after the fact. Both have pled not guilty. A third person charged with being an accessory after the fact, Giovante Thomas, did not make a court appearance Thursday. It is not immediately clear if Thomas has entered a plea. Goodman did not disclose a motive for the killings, but Drummond is believed to have targeted the 4 victims, according to the Tennessee Bureau of Investigation. Drummond's girlfriend is the sister of Courtney Rose, the infant's grandmother. The teacher accused of fatally stabbing an Arkansas couple while they were hiking with two of their daughters pled not guilty to 2 capital murder charges on Thursday. Andrew James McGann was arrested last month accused of stabbing Clinton Brink and his wife Kristen Brink and charged with 2 counts of capital murder. Authorities said that McGann made statements to investigators indicating that he had committed these heinous acts and that his DNA was found at the crime scene. In a brief statement, the Washington County Prosecuting Attorney's Office said that the state continues to pursue the death penalty in McGann's case. According to police, the Brinks were fatally attacked while out hiking in Devil's Den State Park with 2 of their children, ages 7 and 9. Investigators believe that Clinton was attacked first while Kristen brought the kids to safety. Authorities said she then returned to help her husband before being attacked herself. The kids were not injured in the attack, and officials said last month they do not believe they were targets. Arkansas State Police Director Mike Hager said last month that officials have no reason to believe that there was any known association between our suspects and our victims. McGann was taken into custody after a days-long manhunt. He was arrested at a barbershop in Springdale, about 30 miles north of the park. McGann had recently moved to Arkansas from Oklahoma and had been hired to teach in Springdale, though he had not yet started. Prior to that, he worked in schools in Oklahoma and Texas. McGann's next hearing is set for November 14th. No DNA recovered from the scene of an Ohio nurse's killing matches that of the man charged with her murder, a defense attorney said Thursday. Former divorce attorney Gregory Moore, accused of aggravated murder in the 2013 stabbing death of his client Aliza Sherman, was in court for a pretrial hearing on Thursday. According to the motion, DNA evidence was collected in March of 2013. The DNA evidence was found on the watch and wristband of the decedent. The DNA evidence was initially tested, and the results indicated that the DNA was likely derived from blood, that the DNA was that of a male, and that the DNA was not that of defendant or Mr. Sherman. Prosecutors said the state received the motion and will respond within the undisclosed written time frame. The motion filed by Moore's attorney, John Pyle Ryan, calls the DNA evidence critical, material, and incredibly exculpatory evidence and requests retesting of the watch and the swab taken from the interior of the watch band. Moore was indicted on May 2nd on 10 criminal counts, 1 count of aggravated murder, 1 count of conspiracy, 6 counts of murder, and 2 counts of kidnapping in Sherman's murder in March of 2013. Sherman, a nurse and mother of 4, was stabbed 11 times outside the Stafford Law Company, where Moore worked in downtown Cleveland. Moore was Sherman's attorney in her divorce proceedings at the time of her death. Moore's next pretrial hearing is scheduled for August 28th. A 38-year-old alleged serial killer in Oregon entered another plea on Monday after being indicted for a 4th murder charge last week. Following his indictment for the November 20th, 2022 murder of 22-year-old Kristen Smith, Jesse Lee Calhoun pled not guilty to second-degree murder on Monday. He also pled not guilty to abuse of a corpse. Calhoun, also accused of murdering 3 other women, Charity Lynn Perry, Joanna Speaks, and Bridget Leanne Webster, after the bodies were discovered in Oregon and Washington 2 years ago. In April 2023, Speaks' body was found at an abandoned barn in Ridgefield, Washington. A few weeks later, Perry's body was found near Ainsworth State Park, and days after that, Webster's body was discovered near Mill Creek. In May of 2024, Calhoun was indicted for the murders as he was already in custody at the time for parole violations. Previously, Calhoun had been in prison after he was charged with 3 counts of unauthorized use of a vehicle, assaulting a public safety officer, and first-degree burglary. In 2021, then Oregon Governor Kate Brown signed a commutation to provide clemency for certain prisoners, and Calhoun, who met the criteria, was released. The clemency was later revoked by Governor Tina Kotek in 2023. Calhoun pled not guilty to 3 second-degree murder and second-degree abuse of a corpse charges in June 2024. Calhoun has also been named as a person of interest in the death of Ashley Real, age 22, though he has not been indicted in that case. I was checking my emails for criminal defense inquiries, and I had to wade through what felt like hundreds of spam emails just to find a few legitimate ones. It was frustrating, but more than that, it was a wake-up call. That kind of junk doesn't just show up by itself. So I Googled myself just to see what was out there, and it was disturbing. There were sites that listed my telephone number, my email address, even the names and addresses of my friends. And I didn't put any of it out there. It made me feel very exposed, and I'm sure many of you feel the same way. That is why we are very excited to announce our first ever sponsor, Aura. If you've ever wondered how scammers get your phone number and why you have an inbox full of junk, this is why. Brokers collect and sell your information without your permission and make billions doing it. Even though they are legally required to move it if you request them to do so, sometimes getting that done is almost impossible. Aura does the hard part for you, automatically requesting removal from those shady websites and keeping that info off from them. We talk about security and crime all of the time on this channel, and I wasn't protecting myself. I was like the plumber whose own pipes leak at home. It's an all-in-one digital security platform. You get alerts if your information is found on the dark web, fraud alerts from your bank, a VPN, an antivirus, a password manager, and even $5 million in identity theft insurance. It's all in one app with US-based support 24/7. That's why I chose Aura and why we are recommending it to all of you. You can try it free for 14 days if you just go to aura.com/courtroomconfidential. In those 2 weeks, you'll see exactly where your data is being exposed and sold. I'm not leaving myself vulnerable, and neither should you. It's a great product, and it's a great way to support the channel. Please check it out. Before we get to what's on the docket for next week, I just wanted to say thank you. Thank you for being a part of this growing community, but to give a special shout out to Courtney A. Cowan for their review on Spotify, and to our CC crew members, Tendy G and Jules71 for your support over on YouTube. We cannot thank you enough for all your kind words. Please keep those reviews coming. We appreciate your help in spreading the word about Courtroom Confidential. On the docket for next week, Connecticut woman Kimberly Sullivan, who is charged in connection with the alleged 20-year confinement and abuse of her stepson, is scheduled to appear in court Tuesday, August 19th for a hearing. Courtney Clenny, a Miami social media influencer accused of fatally stabbing her boyfriend, Christian Obumseli, in 2022, will be back in court on Wednesday, August 20th for a status conference. After more than 35 years in prison for the 1989 killings of their parents, Eric and Lyle Menendez are set to face a parole board next week. Eric is set to appear before the parole board on Thursday, August 21st, while Lyle's hearing is set for the following day, Friday, August 22nd. George Billy Wagner will be back in court for a hearing on Friday, August 22nd for a pretrial conference. Wagner and his family are accused of killing 7 members of the Roden family plus 1 member of the Gilley family over a child custody dispute in what has been called the Pike County Massacre. And finally, please join us this Sunday for our special question and answer series, Sunday Fun Day. All are invited to leave us a voice message at thecourtroomconfidential.com, which I will answer live during tomorrow's show at 9 a.m. Pacific, noon Eastern. You can find the live stream on YouTube, X, and Facebook. And that is it for us this week, folks. I am your host, Josh Ritter. You can find us on social media at CR Confidential on X, at The Courtroom Confidential on Instagram, or at thecourtroomconfidential.com. Thank you again for joining me. Have a great weekend, and I will see you again next week for another episode of Courtroom Confidential.